So officially, good morning. Thanks for turning out. It's good to see so many people come out for this event. We do ask that you turn off your cell phones. If you need to use the restrooms, they're out the door and to the left and to the left. We are not validating parking for this event. You have to use the pay machines if it goes long. But we'll try to wrap up quickly. So my name is Daniel Costello. I'm the Public Information Manager for Rent Control. Thank you. And I'm here with Stephen Nice. He's one of our information coordinators. So the Public Information team has 6 people who are kind of the front line for the agency. So when you call or you send us an email, they are the people who are taking your calls and responding. So we do have resources available. We do answer the phone. It's not the 311 system. You call us directly, and we can usually connect you with somebody pretty quickly. So with that, I'll let Stephen sit down, and I'll do the first part of this presentation. So we're going to pause throughout the presentation for your questions. So if you could hold them during the presentation part, and then we'll have a question slide, and that will be your opportunity to ask questions about the information that was presented in that section. So today we're going to go over a few things. One is our civics information system. May I see by a show of hands how many people have a civics account? So not very many. So civics is our program that allows you to file registration forms, tenancy registration forms, etc., all online. And you have your own dashboard, and I'll show you that in a minute. But that's a way you can keep track of the tenancies that you've registered and get more information about a property. So if you haven't signed up, I'll show you how to do that, but I encourage you to do that. We're going to go over rent control in general. If you're all veteran landlords, I expect that you know most of this, so I'll go quickly over that. The registration requirements, there's not a whole lot that rent control really requires of you. It's really keeping the ownership information up to date, mailing information up to date, and all of the tenancies. And then there is the registration fee that has to be paid as well. We'll also talk about what is the maximum lawful rent. This is, we are rent control, so we're really about what is the lawful rent. And there are some components to that. It depends on when people moved in, whether property was sold recently, and other factors. Then we'll talk about the petition and complaint process through our hearings department, so that there are some petitions that are filed by landlords, which we'll talk about, and then there are some that are filed by tenants if they feel like you're taking away amenities or not maintaining the property, or you've charged excess rent. And there are limitations in the rent control law for eviction. So the reasons for which a tenant can be removed from a unit are limited. There are about 10 reasons. 7 of them are the cause of the tenant, and 3 are no-fault evictions. And then we'll talk about the last part of rent control, which is limitations on the change of use of a controlled rental unit. So, as some of you have discussed with me already, there are issues that come up in the landlord-tenant relationship that are not covered by rent control. There are many things that are not covered by the rent control law. Again, we're really about the rent. So that includes things like the return of the security deposit. And I don't know if you're aware, but there are some new state laws regarding the return of the security deposit and how you need to take photographic evidence to document those conditions for which you would make a deduction. We have information about that on our website and some links to the California Department of Consumer Affairs with more information. We also don't cover the right of the landlord to enter the unit. That is something that is under state law. It's not a local law. Eviction procedures, so how you notice the tenant, what the process is in court, those are all things that are not rent control, we do have some substantive provisions that require that copies of eviction notices be filed with us, and the city attorney's office has similar requirements. We'll talk about those a little bit more. I don't know if you can just get, I don't have, not displaying here. One moment. Okay, so there are also things that are covered in city laws that are also not rent control, like permanent or temporary relocation when that's required, building code violations, the smoking laws. You know, we often get calls from tenants who are complaining about other tenants smoking, and those are all covered by the anti-smoking ordinance that the city has, and we really would just refer people with these kind of questions to the city attorney's office. So now let me just jump over. I'd like to show you our civics application. So the way that you can get an account is by following one of the links on our website to get an account. You can email us, actually. You can email us at rentcontrol@santamonica.gov, or you can go to rentcontrol.santamonica.gov, and at the bottom you'll see create a profile, and you can click on that link and give us your email and properties that you own or manage. And it takes a couple of days, but we will set up an account for you. We have to verify that you are the authorized agent for that property or the owner of that property. Once we do that, we set up an account for you, and we associate your account to the properties that you own so that they will appear on your dashboard. You will get a temporary password to log in, and then you can start filing forms with us. So there are a number of different types of forms that you can file through the system, and you start by selecting Submit a Record at the top. And that gives you a list of forms that you can submit. The most common one that we get, and we get about 2,500 to 3,000 of them a year, is a tenancy registration form. Is it slow? But you can do tenancy, you can add amenities, and we'll talk about adding amenities and additional rent for those. You can submit a change in mailing address. There are some fee waiver applications, so for owner-occupied units, you can apply for a fee waiver. And the key thing for civics is that for all the forms that you file, you need to identify what we call the primary site. So the primary site, in the case of a tenancy, is the unit. Let me refresh this. There you go. So when you click on a tenancy registration, and it does help to read the instructions. People don't like to read instructions, but we did try to give you some details there. The first thing we'll do is just select that this is a tenancy after January 1st, 1999 because of Costa-Hawkins, and you're right to set a new base rent with a new tenancy. And then you add a primary site. And the trick here is, because the system is looking for an exact match for whatever you enter, the best thing to do is just to enter the number, the street number, and the street name. And you don't add avenue or street or boulevard or anything else. So the street name, we'll do Centinela, and we'll do King 31. And then you hit search. You don't have to fill out any of the other boxes. And then the system will return the units that exist at that site. And you just click one of the radio buttons to select the site that you want. And you'll see it appear here. And on this first screen, that's all you need to do. You're just telling us which property are you registering a tenancy. And then, there's just one more page for entering information, and it's pretty straightforward. It's the unit number again, we want to confirm that, the number of bedrooms, some basic property owner or manager information that's optional. But what we really are looking for is, when did the tenancy begin? Unfortunately, due to limitations of the system, we do have to have some hour. It doesn't matter, you can enter anything. Most people just enter one. And we need to know the initial monthly rent, if you're charging a registration fee, any surcharges, and what the total rent is. Then if there's parking for a tenant, you enter the parking, and why the prior tenant vacated and the reason, and then you just complete an online signature, which is this certification of information section. And for all new tenancies since July 31st, 2017, you have to give the tenant the rent control information sheet. We send that out to you every summer in the notice of the increase for the general adjustment. It's available on our website. You can call us or download it from our website. So you do have to make sure to check this box. Otherwise, the general adjustments for that unit will be blocked, because that is a requirement to qualify for general adjustments. If you can't finish a form, that's fine. You can just save and continue, and you can come back to it later. So once you've submitted a form, it comes to us for review. It's open for 1 hour. If you need to make any changes, like you realize I entered the wrong unit or something like that, or the wrong rent, we keep it open to you. But after 1 hour, then it gets closed and we begin to process it. You can see, this is my dashboard. I've made myself an applicant on some of these forms. I have a tenancy registration form here. This one was not accepted, some are closed, like this one is closed. When it goes to close or completed, then you know that we have processed that form. If you see that there are pending tasks, so they'll be identified in red, then that means you need to correct something on the form. What happens is we will identify whatever issues there are with the form, and we can send you, when you have the system, we can send you an email, and the email tells you what the specific issues are with that form. And then you can come back here and you can just edit the form, and we tell you which section to edit, if it's the rent or something else, maybe the parking information. And then always, once you've made those changes, you complete that certificate or certification of information once again. When you do that, that's you're signing in again, you've made changes, and it comes back to us, and then we can continue to process the form. This is improvement over the way we used to do things, because we had paper, it was always paper, and if you had to make a change, we'd have to mail it back to you. You would make the change on the form, and then you'd have to re-sign the form and send it back to us, and that's just not efficient. So we really would like all of you to become familiar with this. We do send you the alert by email, letting you know there's a problem, and then you can resolve that fairly easily. So you just go through, and again, you'll have to recomplete this certification of information to send the form back to us. Okay? There are some other good features on Civics that I don't think maybe everybody is aware of. Go back to the dashboard. So we are approaching the summer season when the rents go up, and we charge the registration fee for the year. So if there are fees due for properties you own or manage, they're going to appear here in the My Fees box. There also will be something called an annual bill on your dashboard, and you can open that and look at the details. So there's one right there. And all you need to pay online is this bill number. This is the invoice number that you'll enter when you're going to make a payment. So that's convenient. But what I really want to show you is there are also site masters. So I mentioned when we set up your account, we're going to associate the properties to your account. And so this site master for your properties will appear on your dashboard. If you click on the blue hyperlink for that site master, it opens up some details, including a My Documents window. Sorry, the internet's a little slow here. I'm not plugged in. High-tech city. So anyway, there will My Documents will appear here, and you can click on Property Summary, and this is a real-time summary of the information that we have in the database for your properties, and it includes every unit on the property and the complete MAR history for that unit going back in time. And this is similar to those of you who know the old printout that we used to have from our old system. It's got basic ownership information, if there are any fee waivers or exemptions on this property. And then it goes into the actual units, and it lists what amenities are recorded for that unit, if there's been a market rate tenancy, and then every general adjustment from the most recent one back in time will show in this history. So this is a really easy way. So for example, to see if you have registered your tenancies. Rather than sending us a duplicate form, you can check this report and confirm. So for example, there was a tenancy that began on August 1st, 23 in this unit, and if this was the correct rent, then you can also rely on this MAR. So it's a helpful way of getting information about the properties, and that's available on your dashboard in Civics. And that's all I'll talk about on Civics there before I move on. So here's the QR code. I think I've been taking pictures of that. It's rentcontrol.santamonica.gov, and that's how you sign up. So any particular questions about Civics? Yes? Yeah? Okay, we're going to bring the microphone back because we're going to try to pick that up.
Can you make multiple accounts for the same property?
Yes, you can. So if you're a property management company, for example, individual property managers could submit forms to the same property. The only thing is that unless they're somehow related on the back end, and we have both people listed for the property, that form that you submit is only going to appear to the person who submitted it. So it is possible also to get what we call a company Civics account. So some property management companies just have a general account that everybody in the company uses, and therefore anybody who logs in can see every form that has been filed. And there's a question when you request your account whether you want an individual account or you want one for the company.
I think you just answered my question. The information that you said, you can see the history, you can see all the rent. Is that available to anybody? Can anyone look up all that information?
So to get that whole history, you would have to be what we call an applicant on that site master. So it has to appear on your dashboard. The only way it's going to appear on the dashboard is if you are the registered owner or an authorized agent of the property owner.
So that's different from the published rents.
That is different from the published rents. We do have we'll get to that, but we have a look up a rent feature on our website, but that is only the current rent for that unit. It doesn't give you the whole history. So this is more information.
Okay, we'll talk about that later.
Okay. I think we have one in the back as well.
I have Civic account for several years, I guess. the best feature of that I could use is tenant registration. So that is so easy to pay. And the most difficult part is the tenancy registration form. So far, I was not successful to do any of them. And I was wondering that if anybody else in this group has a good experience about the tenant registration. And my other question is that do you still accept the tenant registration paper form, or it only has to be through the city?
Right.
Okay.
Sure.
Thank you.
To answer the second one first, yeah, we will still accept paper. We're trying to avoid that simply because it requires data entry and there can be errors and it's a little bit more labor intensive, but certainly for some of our older property owners, they don't want to use a computer, so we're maintaining that legacy system as well. As far as the difficulty submitting the tenancy registration form, I think probably the issue that most people encounter is they're entering too much information on that first form that I showed you, where they're entering more than just the street number and the street name. You know, so we have half units and things like that. If you start to enter those things, if it doesn't match exactly what we have in the system, there'll be a mismatch and you won't be able to register. So if you're having a problem, just call one of the staff people and they can step you through, you know, step by step how to get that form filed. Okay.
So we can share a screen and they can fix for us?
We don't, I mean, if you were open to it, we could probably set up something where we could share a screen, but they can follow along with you and tell you, they can look at the same screens you're looking at and say, okay, in this field, enter this. In this field, enter that, and then hit search. Keeping it simple.
I don't think I have problem to navigate. It just, I couldn't just finish through. But I only tried 2-3 times because there was there are not so many just turn around and the registration. But we have a very good feature in the civic account. Many of the features are really user-friendly, but that part, my experience was not being successful so far.
Yeah, I'm sorry about that. Again, staff could probably help you. We know that people are successfully using the system because, we do get several thousand every year. So it's working for some, for sure, but maybe we can help you just troubleshoot. Any other questions on this section? Okay. So I think all of you probably know this, but I like to talk about rent control as kind of having 4 legs. There are 4 important parts to it. One is control over the rent. And so all rent increases during a tenancy are controlled. Of course, for new tenancies, in most cases, you can set a new base rent with an incoming tenant and new amenities. We also have remedies when excess rent is charged, or if maintenance is neglected, or amenities are removed, or an owner is no longer making a fair return. And we'll talk about that a little bit more. But those are our administrative remedies through the hearings department in our office. There are also eviction protections, as I mentioned. Without having eviction protections, having rent controls isn't very valuable because any landlord could just terminate the tenancy and get a new tenant with a new rent. And then finally, the rent control law protects the units themselves, the controlled rental units themselves, the housing stock. And there are only a couple of ways that a controlled rental unit can be transformed into something else, either through the Ellis Act, which we'll mention a little bit, through a removal permit, which is typically a redevelopment permit, where you're agreeing to bring back as many rent controlled units as were there before. But those are really the core components of rent control. And it's not a lot of the other things that come up in the landlord-tenant relationship. So, we have rent control units all over the city. I think in our last annual report, there were about 27,500. We also have certain exemptions for properties. A lot of single-family homes are exempt. The rents are decontrolled if it's a condominium, single-family home or a condominium that has been separately sold after January 1st, 1996. And the state doesn't allow us to control the rents. We also have owner-occupied properties of 3 units or fewer. And as long as the owner lives on the property and has at least a 50% interest, then their application to the board is likely to be granted, and then that property will be exempt from rent control, all the provisions of rent control, while the owner continues to qualify. And we do send annual recertifications to make sure that owners are still living on the properties, and they declare that to us. We have a lot of ADUs being built in the city right now, and some of those are rent controlled and some of them are not. If it's purely new construction, then under state law, we cannot impose rent control on it. However, if it is a unit that has been converted from rent controlled space, and that includes garages, laundry rooms, rec rooms, whatever other space is available on the property, if that's converted, then it does have to be registered with rent control, and it will be subject to the rent control law. You mentioned the owner-occupied properties of 3 units or fewer. Obviously, it has to be 3 units or fewer. The owner has to live on the property continuously for 120 days before they can file the exemption application with us, and that's to verify residency. And then if they have 50% interest as a natural person, so LLCs cannot qualify for owner-occupied exemptions, nor can certain trusts, but revocable trusts, where the trustee and the trustor are the same person, is considered to be an individual, and so those will qualify as well. So I'm going to turn it over to Stephen here to talk about our registration requirements.
Right for technical difficulties today. Thank you all for being here. My name again is Steve Nice. I'm the information coordinator with Rent Control and Santa Monica Rent Control tenant myself. I'm going to be speaking about registration requirements and maximum lawful rents. So what are the ownership registration requirements as of ownership registration? Obviously is the big one. Registering anytime there's a change in title, i.e. a trust or putting into an LLC. Agent authorization, so if you're authorizing a property management company or an on-site manager, registering new tenancies, as Dan was talking about, and amenities. Added amenities would be that added amenity form. It's a parking, storage, or pet amenity. And that's for post-1199 tenancies. And registrations must be done within 30 days. So what happens if you fail to register? The right to implement a rent increase may be restricted. A rent increase to a tenant while registration is not proper may result in the collection of excess rent until registration is proper, and rent withholding can be ordered until the landlord comes into compliance with that law. So 1-year minimum lease terms are a requirement in Santa Monica per Santa Monica Municipal Code 622. And it requires residential housing units to be rented to tenants who will use and occupy the unit as their primary residence. Lease for an initial term of no less than 1 year, lease unfurnished, and lease to only natural persons. There was a stay on that with the emergency order, but it has been lifted as of right now. Owners must collect documentation from the tenants. So separate agreements for pre-1199 tenancies. Property owners and tenants may negotiate a separate agreement with these tenants for monthly rental of amenities that would not be the base amenity as of 78. The separate agreement must be negotiated separately from the rental agreement. It must contain terms comparable to the similar arrangements in the unregulated market, and the continued existence of this agreement is not a condition of the tenancy. The breach or termination of the agreement is not grounds for eviction. So if it's a pre-1/199 tenant, this is going to be fewer and fewer these days, but if you are adding an amenity for that person, it would be an independent agreement between you and them. It's- No. For post-1/199, it would be. For the post-99? So for post-99, there would only be really three, which I have right here, and that would be parking, storage, and the right to have a pet. Yeah.
What about EV charging?
So EV is incentivized by state law, and it is, they do, incentivize that. But at the end of the day, we don't really add that as an amenity. Typically, it would need to be added as a base amenity.
I'm saying like the EV charging is swapped out of the tenancy itself. Is that considered additional?
Dan, on this one?
Yeah, so there is a provision that allows owners and tenants to agree to have an EV charger. Typically, it may be that the tenant pays to the utility, and so that's not money that the landlord collects. But it's not, we don't, there's no change to the rent for that. But that is something that is just about that utility. So if it's separately metered, that's ideal, but that is okay to do.
Right. Okay. So getting back, like I said, those three amenities that you can add onto a tenancy would be that parking, storage, and the right to have a pet. And such amenities become the base amenities of that tenancy and becomes part of the market. The requirements would be that they must result in an arm's length negotiation with no pressure to the tenant to accept the amenity, and the amount paid must be comparable to the lawful ratings of the unregulated market. And the owner must register the initial amount charged for the amenity with it. And you can do that on Civics. Any questions on this portion?
Are you saying that the right to have a pet is an amenity, or is there a charge for having a pet? Or does the owner have the right to decline the tenant's pet?
That would be correct. It would be up to the owner if you want to allow to have a pet, as long as it's on the lease stating they can't have one. It's up to you if you want to allow them, and then you would register that amenity with us. That would be different than a support animal, though. Per state law, support animals are not pets.
Okay, and so what are the requirements for the tenant to show that this is a comfort animal?
So I believe they would just need documentation to show that. It is state law, so it doesn't really get into rent control, wheelhouse.
Okay. So you have the right to decline any pet that's not a comfort animal?
Correct.
Okay, thank you.
Yeah, and I would just say actually service animal. So there's slight difference between, service animal is trained to perform a vital service for that person who has some sort of disability.
So that's different than
That's different from a comfort animal. Those are not protected. So, right. So if your lease says no pets and the tenant brings in what they call a comfort animal, that appears to me to be a violation of the lease. You can give notice to the tenant, or warning notice to the tenant that they need to comply with the terms of the rental agreement, or not. If not, you could seek eviction.
And you have the right to turn down an applicant
The question is, can you turn down an applicant because they have a pet?
Yes.
Yes, that's up to you. If it's a service animal, then no, you can't, because that would be discrimination.
It's very complicated beyond Santa Monica rent control. You have to look at
your requirements and post them before you offer rent. And you have to evaluate this under the state law as to whether or not the animal qualifies to be a comfort entities. Beyond this seminar, as far as that goes.
Yeah, we do have resources that staff can refer you to the Disability Rights Legal Center, and they can advise, you know, what your requirements are if somebody's claiming that they have a service. Okay. Our esteemed former Rent Control Board Commissioner.
Open for business. Question, let's say a person marries either a man or a woman or whatever, and they move in. The original tenant passes away. Does the spouse have a right to the unit at the same rent that the original tenant paid?
I believe that varies on a case-to-case basis. When they are in the unit as they are married, they are protected by the same rights as a tenant.
Yes, stop there. Yes, we understand that. The original tenant
Right.
was single, married. The original tenant passed away. The spouse is an occupant, I believe. Are they entitled to the same rent, or does the unit go to market?
I believe that does vary case-to-case basis.
What would be the basis? It's black and white, is it not, gentlemen?
No, it's not. It's not. So this is a very complicated situation because it could be that the landlord establishes a direct tenancy relationship with the spouse. So, for example, you begin collecting rent from the
We
spouse.
don't do any of that, just straightforward, original man or woman
Right.
gets married, the original tenant drops dead. Does the spouse occupy the unit the same rent or not?
Yeah. The general
And then
rule for everybody.
They don't have
Okay.
collected money,
Right.
they know what they're doing, like Mr. Milburn.
You know, the general rule in the state, because of the Costa-Hawkins Rental Housing Act, is if the original tenant no longer lives in the unit and the unit is occupied by a subtenant, then the landlord can reset the rent with that person. There are complications when they are married, and there was a recent court case where it was determined that the spouse was not a subtenant or a lawful sublessee or lawful assignee. And because they had never paid rent, they were not a subtenant, only the departed spouse paid the rent. And in that case, the court said, no, you cannot set a new base rent with that person.
Well, obviously, the children can stay for as long as they want if they're born there. Can't get rid of them either.
Well, that's, it depends, you know, it depends where they, you know, it could be that, the landlord does not have a relationship with those people, and, when the parents leave, there's a possibility you could reset the rent. These are very case-specific, situations, and, we have something called a base rent petition, and the tenant can file that if they believe that their rent was unlawfully increased. And our hearing officers or our attorneys look at all the situation and determine whether or not that increase was lawful or not. So unfortunately, there isn't a black and white answer.
My question is about adding a pet. When it's mentioned that when at the parking or storage, then the additional charge has to be based upon market value of unregulated unit. For us, it's so easy to determine that how much the storage in as market value could be, or parking, and we can just show the comp. But when it comes to adding pets, it's all different. It depends on the size of the pet, how dangerous the pet could be. And it's really, really difficult for us to come with how much market value could be for adding that pet. I believe that different control is coming after property owner to determine their own value to or price to ask for that pet. It's better just to come up with a range of recommendation that, okay, so if the dog is a little chihuahua, it could be the range, or if it's, I really want rent control protect property owner when they give them some sort of guideline that the price that you're adding has to be based upon the market price of unregulated. Thank you.
Yeah, I see what you're saying there. I mean, I think she's asking, what are the differences in pets? Because obviously, a cat can be different than a large dog. And I think even looking at rental listings online, you see like for a large pet, it can be greater, and for a smaller pet, it can be a smaller amount added onto the rent. So I think that's kind of what the market is. It just can't be an exorbitant amount that would be greater than what would be on the unregulated market.
Yes, and we haven't, we really haven't seen any petitions, on that. But you, as the landlord, are in control. You can decide whether or not, in the first place, to allow the pet. And then you negotiate. It's like, well, what are you willing to pay to have Fluffy?
So as long as the tenant accepts to pay, it's okay, so you're not gonna come and say $150 is a lot for just a dog?
Theoretically, a tenant could file a petition claiming that the amount set did not meet the requirement of being something that's, comparable on the unregulated market. But as I said, I've never seen that. Generally, tenants are very happy to be able to have those added amenities and typically don't raise a fuss about it.
I have a tenant that signed a lease that wasn't gonna have any animals. Now they do babysitting, they sit the animals, it's not just one, and it changes to different kind of animals every month, and I don't have, I don't know what to do about it.
So if it's on their lease that they're not allowed to have pets, that would be at your discretion whether you want to enforce that lease.
But they've been there for a long time, and within a couple of years back, they started having babysitting animals, keeping the animals for a week, month, and I don't know how to go about it. Where is the rent control? How would you go about this?
I think it's at your discretion then to enforce that lease if they're not allowed to have pets.
So,
what would you do?
Call Dennis Block.
well, okay, no, don't rush it. One of the things to consider is that even though a lease may have explicit terms, if over time there have been implied changes, so you look the other way when the tenant does something, then it may be difficult to then try to seek eviction, which is the ultimate remedy for enforcement of the lease, if you've allowed these changes over time. So when you perceive a lease violation, it's important to give the tenant a warning right away, and then, either act on it or.
Well, they say it's temporary. It's maybe a week too, and then maybe for a month it's quiet, and then again, the problem starts. Like, I don't have the control. I don't go in every day to take a look what they have, or every week.
Right. It's not.
This is really a landlord-tenant dispute that requires a lawyer to give proper notice and to allow to cure. But Dan and his staff are here to talk about Santa Monica rent control, not necessarily.
Thank you. And I think you had a question too?
Yes.
Now, I noticed in one of the things about how you can change for rent controls, if the landlord's not making any money. But what happens if you have this long-term tenant who's been there for 20 years, and all of a sudden your insurance goes up, your property taxes go up, you're still paying mortgage? What happens when you're not making any money?
We will address that later on in the presentation.
It's gonna happen soon. Insurance has gotten really high.
Sure. Yeah.
Okay, my question is the first one, new tenant, tenancy registration, for instance, the move in the January 1st, 2024. So then we are missing because of the hospital, something like that happened, you know. So then, can I be registered?
Yes,
Yeah, it's not too late to register. You still can submit that registration, and then it will be in our system.
For instance, I registered today,
Uh-huh.
so in order to rent control, to raise rent,
Right.
so that it should be after 1 year residence.
You said they moved in January 24.
January 1st, January 2nd, last year, we moved in.
In 24.
Yeah.
Okay. So yeah,
And we now come usually receive the paper for apartment around July, something like that. And before that, can I register tenancy? It's okay.
yeah, of course. As long as you register that tenant.
Okay, and I can raise.
Yeah. Yeah.
And for instance, the tenant, the landlord, yesterday, they received the apartment control paper.
Right.
So then, certainly, pay amount of, for instance, 3,500. That's all the tenants rent, but the piece of new rent is coming 3,700 based on the market price, you know.
Right.
So then can I, at this moment, from the 3,700 now, then can I increase based on the
Yeah.
CPI?
If you register that tenant for the upcoming billing this summer and you pay your annual bill on time, then you would be able to implement the increase in September.
Yeah, so it's a prerequisite to qualify for a general adjustment that the tenancy be registered. And that's why we send you the MAR report in June, and it lists the date of tenancy for each one of the units. And that's for you to check your records and make sure that the tenancy is registered and that you're going to be giving the correct increase when September comes. But as long as you haven't increased the rent on the tenant, while they've not been registered, you're fine. You just got to get it registered so that you qualify for September's increase. Okay.
Another question, the water charge, now is very going up, the water, and also a lot of trouble with the tap. So that whatever, before we make this agreement, tenant agreed, okay, I gotta pay for tap, whatever, something like that. In the case, both agreed, for instance, tap, you gotta pay additional $50, for water, $70, something like that, agreed. Then, in this agreement, I gotta put the total amount, not the separated, So originally said 700 plus 50, 70, total 3,820. Can I make this agreement? Even if after I gotta put it there, they cannot pay the 50 and the water 70, something like that. Is it okay?
You wouldn't break that down to us if you're familiar with that.
Total is agreement, but not breakdown.
Right. I'm speaking on the.
You want to do that, actually be paid or not, something like that. So therefore, I have to, in the demand, I put it, okay, including water 70 and 50. It is a total rate amount. Can I put it down? Is that not enough?
So on the tenancy registration for what's the initial monthly rent, you would include exactly all those charges, what the initial monthly rent was. What the total rent would be if you collected that $9.50 rent control registration fee. That would be the only difference between the two. And I will go into the
So
difference
then,
between those in just a minute.
rent control office, okay, says that, okay, you don't charge water, or you don't charge tax.
So it would have to be from the start of their tenancy if it is water. It would be whatever the utilities are from the start of their tenancy. If they're being paid directly to the landlord, it has to be included in that.
Okay, another tenant. We have the medical data. He moved in. We have a laundry room separated altogether. But he told me that this very specially, he did clean clothing very often, every day or every 2 days, something like that. So therefore, he asked us completely separate for himself in the washer dryer. So therefore, okay, we consider that special cases. So I put it down here, only for him, washer dryer. So then the almost several years, then the something problem coming from the washer dryer. In the case, can I ask the tenant to take care of fixing or problem?
So it would be the landlord's responsibility to fix any amenities in the tenancy.
Okay, last question. You have anything in the election, how can I see that information? Can I see some of the rent control website? Okay, just so you put it out.
On the landlord's responsibility for repairs?
Only you explain the several items, you know?
Oh, so this
Yeah.
presentation will be up on our website. And we can give you that information at the end where it will be posted.
Website?
Yes.
Okay.
Yeah.
Thank you very much.
Sure, so yeah, this presentation will be up on the website, but also we have, under registering registering tenancies and amenities, we have more information about adding parking, storage, or the right to have a pet there, and the form that can be used. Again, you can use the civics application for doing that as well. Okay, thank you.
All right, moving on. So now we cover the maximum lawful rent and the difference between that and the maximum allowable rent. So how much rent can a landlord charge? The maximum lawful rent for existing tenants is determined by adding together the following 3 components. That would be the maximum allowable rent, the registration fee pass-through, that is currently $9.50, and the allowable surcharges for property taxes. That's how you get to the maximum lawful rent, or the MLR. So what is the maximum allowable rent, or the MAR? The MAR is the base rent plus any allowable increases. Annual increases are per general adjustments, and the addition of certain amenities, like I discussed, may result in allowable increases. So again, there's that calculation, the maximum allowable rent plus the rent control registration fee pass-through and the allowable surcharge. This brings you to the maximum allowable rent. So how is the base rent determined? For pre-1199 tenancies, the base rent is usually the rent in effect as of April 10th, 1978. And then obviously it accrues from that point. And then for post-1199 tenancies, the base rent is usually the initial rent charged at the beginning of each new tenancy. So what determines that general adjustment, or the GA? The GA is based off of 75% of the annual change in the Regional Consumer Pricing Index, or the CPI, for the Los Angeles area for the 12 months ending in March. The board each year retains the authority to apply a maximum dollar amount based on a formula in the charter, and the GA for this year has been announced at 2.3% based off of that calculation. The board will be holding a public hearing on June 12th, and we'll discuss that dollar cap, which is calculated as of right now at $60, but it is open to public comment, and that $60 would be for rents for 2,587 and above. If the unit qualifies with proper written notice, the GA can be applied and implemented as of September 1st each year. If the owner did not implement a previous GA, it does not expire and can be prospectively implemented with proper notice. So those continue to accrue in our system. So when can a GA be taken? Like I said, it was September 1st of each year or any time after, only if all registration fees have been paid and any penalties, the tenancies and property are properly registered, the rent control information sheet was given to the tenant and that box was checked on the tenancy registration. There are no uncorrected citations or notices of violation for health, safety, or housing laws for the unit or property, substantial compliance with rent control law, the owner gives proper written notice, and the tenancy has been in effect for at least 12 months. So it needs to be the first September after that 12-month term. How can you learn a MAR for a specific unit? So each June, as Stan was talking about, we do send out those MAR reports to assist in comparing the rental increase notices, and you can check tenancy dates for accuracy. And on our website, you might be familiar with that look up a rent tab right there. You can utilize that to look up the MAR for a specific unit. So registration fees, as I'm sure you're aware, an annual registration fees is for controlled units is charged for property owners by the Rent Control Board unless there's a fee waiver for one of those units. The fee currently is $228 per year per unit, but the board is considering a 2025-2026 budget that may increase the fee to $240. As long as the owner pays the annual fee on time, usually by August 1st, 50% of the registration fee can be passed on to each tenant, and currently that means $9.50 per unit per month, and this would increase 50 cents to $10 per unit if the proposed budget is adopted. So registration fee waivers, these would be waivers that can be applied for to waive that registration fee per unit. There are low-income elderly and low-income disabled tenants that can apply for registration fee waiver for their units. Owners may also apply for a registration fee waiver for Section 8 tenants if they take in a Section 8 tenant. Owners holding at least 25% interest in a property and occupying a unit on that property as their principal place of residence may apply for a fee waiver for that unit. And if a fee waiver is approved, registration fees are not charged for that unit, and the pass-through cannot be charged for the tenant.
What about vacant units?
So units are charged regardless. It doesn't matter if it's vacant or not. So allowable surcharges. The allowable surcharges are based off the owner's property tax bill, and these costs can be divided among units on a property and passed through to the tenants. Surcharges for existing tenancies are capped at 4% of the MAR, or 35, whichever is less. Surcharges cannot be passed through as of March 1st, 2018 for new tenants, or if the property was sold or reassessed for value after that date. So you might be familiar with our notice of change in terms of tenancy. This is a little bit of a closer look in the line items for those property tax. The specific costs of the property tax bills are listed on the notice, and they would appear as 5A through 5E, prepared by the Rent Control Agency, myself and my coworkers, for use of the owners in tenants in increasing their tenants. This is a little bit of a closer look. And if you ever need help filling these out, you can always give us a call. We're always happy to help. We get quite a lot of those. So the school district parcel tax exemption, the Santa Monica Malibu Unified School District Measure R. Exemptions for this tax are available to property owners who meet the following qualifications. That would be over 65 by June 30th of the year they applied, and they occupy the property as their primary residence. And you can get an application by dialing the number here if you want to grab this real quick, or you can look at it on our website once it is posted. When the waiver is granted, no school district parcel tax is charged for the property, and the tax cannot be passed through to the tenants of the property. So the Clean Beaches and Ocean Parcel Tax Exemption. This exemption is available for low-income owners who qualify and apply. If granted, no Clean Beaches and Ocean parcel tax will be charged, and no surcharge may be included in the rent for any tenant on the property. To apply, just contact the city's Office of Sustainability and Environment. And a prorated waiver of the tax is also available for the unit of any low-income tenants that apply. If granted, no Clean Beaches and Ocean parcel tax surcharge may be charged to such tenants.
How do you determine if they're low?
So that would be based off of sustainability and environment qualifications. You would have to reach out to that department.
There are published amounts on the form. It tells you, depending on how many occupants there are in the unit, there are various maximum income amounts that make them qualify.
And the tenant would have to qualify, the tenant would have to give you the information?
The tenant applies directly to rent control. We handle the applications for the tenants, and the owner ones go directly to the Office of Sustainability and the Environment.
Thank you.
Any questions for this portion?
I can just speak loud if you want.
I have that if you're talking.
Sure.
Yeah.
Just a quick question with calculating the MAR. You placed a slide about calculating the base MAR, but that explanation didn't come through exactly. And I have a question about like a renting special. So as an example, let's say we're giving a week free, 2 weeks free, a month free. How does that impact the base rent? Is that reported on the full term of the lease? Is that calculated on the 13-month? How do you go about calculating that and then the adjustment following the next period?
Yeah, so that's a good question, and we get that pretty commonly, because it is something we're seeing a lot of these days. So it would be whatever is paid over that 12-month term, whatever that averages out to, that becomes the MAR. So that is the calculation you would need to do when you're filing a tenancy registration.
Okay, thank you.
Yeah.
So we have to account for any period of free or discounted rent in determining the MAR.
How about that, monthly rent? Indicate the charges. I mean, the surcharge, et cetera, rent increasing, at that time, the surcharge is something like that. My understanding is recently, no charge to tenant.
For the surcharges, for the property tax? So if the tenant has moved in after 2018, so any new tenant as of right now, you would not be able to pass those on. But if you have tenants who were there before that date, and as long as the property hasn't been reassessed or sold in that time period, you still can pass those on.
Okay, another question, every rent lease agreement, yearly basis. But after past 1 year, most of the tenants, they want to month to month change. Even month to month also, can I charge the rent increase?
Yeah. In Santa Monica, the end of that year lease term, it becomes month to month on those same terms. So that is, most rent control tenants are going to be month to month, so you still can take that increase.
Okay, thank you very much.
So we'll have to wait till the September after the tenant's been in place for 1 year before you can increase the rent. Okay, Tammy.
As we all know, the Santa Monica sales tax is 10.75, the highest in the nation maybe. So as the Santa Monica property owner, we like to support our local businesses, which means that when we shop at local businesses, we are paying 10.75% tax, higher than other parts of Los Angeles. So would it be fair that when it comes to GA, we request to have 100% of CPI rather than 75%. This is really something that the city council or whoever was in charge of that determination of GA to put it in consideration. Thank you.
You think that?
Yeah, sure. So that would not be within, the purview of this presentation right now. That is in the rent control charter, that calculation. And that is the determination the board makes year to year. You would be able to attend that board meeting and bring that up there.
Which entity can change it?
What's that?
Which entity has authority to change it from 75% to 100%?
So that would be up to the rent control board.
No, the
It'll be the
voter
board of
initiative.
voters. So, yeah, so we'd have to,
Crazy voters.
we'd have to get that on the ballot, and then the voters would have to approve it. So the board might recommend to the council that that be put on the ballot. But I can give you a little perspective. Prior to this measure GA that got passed several years ago, that tied it to 75% of inflation, we used to do an annual study of landlords' actual costs. And many landlords would bring in their financials, and we would look at those and determine what the general adjustment was going to be for each year. And the idea of the general adjustment is to allow the owner to continue to make a fair return. When we compared those cost assessments versus inflation, we saw that they very closely tracked 75% of CPI over many years. So that's why we decided to put before the voters a simplified version of calculating the general adjustment, and that's why it's 75%. Many things that go into the CPI are not things that are typical landlord costs. They may be fuel, costs or other things that aren't really tied to operating a rental business.
Yeah, but to be fair and honest, if this continue, many people would prefer to shop outside Santa Monica for large items and not to pay 75% sales tax. So that local businesses in Santa Monica is going to suffer. So when they come to any kind of decision making, the city and politicians have to consider big picture. So
That's not really our subject here today,
Right,
but
and if you buy something and have it shipped to it's big enough and you have to ship it, the sales tax is paid where it was shipped to. That's where title pays over. So you're gonna pay the Santa Monica tax no matter what.
right, and remember, those taxes were approved by the voters, and it's helped us deal with the homeless problem and other things that are of concern to everybody.
It's a fair subject. Will they be reviewing, when do they review the GA? And I'm asking because what about all the new costs that have been coming into place over the years, like the retrofits, the railings, the air conditioning that they're talking about, et cetera, et cetera. There are a lot of costs that didn't exist before.
Well, no doubt, costs are going up, but so too are rents. Not only is it the general adjustment, we have pretty high turnover in Santa Monica, maybe not everybody, but those are opportunities to reset the base rents so that you have the income that you need to be able to operate the property and make a profit. Some things like retrofitting, that really goes back to 1984, after Northridge. And at that time, if you did retrofitting, you could have passed all those costs on to the tenants. But some people have deferred, doing that safety improvement. So now there's a new cost. But there are, other costs coming down the pike. Obviously, water costs continue to go up. There's a plan that requires that buildings be made 100% electric. There's a long phase-in for that program, And I would encourage, if you want to get information on that, there was a good presentation to the Rent Control Board that's available on our website, on the board's page, and it talks about what the city's plans are for that. But it shouldn't affect too many people
And there'll be no
initially.
pass-through
initially.
to the tenants for that as well, correct?
No direct pass-throughs, no.
Fantastic.
What if you get the 2.3% in, possibility, that's kind of low.
So it is based off of that calculation I was talking about, the 75% consumer price index for Los Angeles. Any other questions in this section? I'm going to turn it back
One
over.
more question.
Yeah, of course.
If you decide like self-heaters or water billing, but you could only charge that to the new tenants and not the old tenants.
That would be correct. Yeah, if they're paying a set amount from the time of move-in, that is their base rent. I'm going to turn it back over to Dan now.
All right, petitions and complaints. So as I mentioned, we have a lot of administrative remedies that are heard by our hearings department, and so I'll just kind of review those. Obviously, since we're rent control, one of the big things is complaints for excess rent. So that's, anything that is above the maximum lawful rent, which were the components that Stephen explained. In 2024, we changed the regulations regarding tenants filing these complaints. They used to just be able to file directly with us, and then we would get in touch with you, the landlords, about their claims. But now they have to actually contact you directly, and we will not accept a petition until we see that they have made some written demand of the landlord for whatever they believe is the excess rent amount. And then if that's done, we wait 30 days for that to be resolved. If it can't be resolved, then we do have a hearing, and the hearing officer will determine how much of the excess rent has been collected, and then authorize, either the landlord can just pay that amount back, or we can reduce the maximum allowable rent going forward until the tenant has recouped what that excess rent would be. And in some cases, if it's found to be knowing and willful that the landlord continued to collect excess rent, then there could be interest and penalties included in the award amount. Some common examples of excess rent are these things like increase for an additional occupant. So as Stephen explained, there are only 3 things for which you can increase the rent once the base rent has been established, other than the general adjustments, and that's for parking, storage, or pet. You cannot increase the rent simply by allowing the tenant to bring in an additional occupant. Also, if you increase the rent but you don't register those additional amenities, so if you add parking to a tenant who didn't have that originally, and they're a post-1199 tenant, then you have to let us know what you and the tenant agreed upon for that parking amenity, and you have to register that. So if you don't do that, then you're not considered in compliance, and then you can't take general adjustments. Utility charges. So as we kind of touched on, if you're asking the tenant to pay $70 for water, you need to include that in the base rent amount at the beginning of the tenancy. We don't have RUBS billing here, so it's a ratio utility billing system where you can take the total water bill for the property and divide it among the tenants, and then that's a variable amount from month to month. So that's not allowed here. You have to really, for the tenants, when they start, you need to consider what your utility costs are. You can't make it a separate charge. Improper noticing of rent increases. We send that summer mailing and give very explicit instructions about how to increase the rent, but I can't tell you how many problems we see. For example, somebody will, instead of basing the increase on the maximum allowable rent for the unit, they'll base it on the maximum lawful rent from the prior year that included taxes and maybe the registration fee. So it's very important to look at the information we send you and kind of follow the instructions. What's on that reported maximum allowable rents, we have columns listing the amounts, and so the amount in column 1 goes on line 1 of the notice. The amount in line 2, column 2 goes on line 2. So, and if you have questions, we have staff, you can just bring in your MAR report and the notices you want to have sent to the tenants that will help you properly complete them. And then the improper pass-through of surcharges, we're still seeing that on properties that either have newer tenancies or the property has sold. And so a new owner of the property might just continue to charge the same rent that the old property owner charged, but since there was that change in title and the taxes were reassessed, they can no longer pass through those surcharge amounts, and so they have to look at the rent and maybe less than what they used to be able to charge, what the prior owner could charge.
What if there was no reassessment? Some ownership changes are exempt and not reassessed.
Right. It's conditional on a reassessment. And the reason was some of these property taxes are based on the assessment, and when you go to much higher assessed value, the amount that the tenants were having to pay increased significantly. And so the board said that if there is a reassessment, then you can no longer pass the charge through. We have talked about this a little bit already, just this separately charge separately for utility costs. If it is separately metered and the tenant pays the utility directly, that's no problem. They could pay a variable rate month to month. They're just paying to Southern California Edison or whatever. If the property is master metered and the lease requires the tenant to pay a share of the monthly utility bill, the owner must specify the exact dollar amount at the start of the tenancy. So that's $70. I'm going to add it to your total rent, and that's what I'm going to register. And as I said, RUBS is not permissible. The petition that we get the most of are the petitions for rent decrease. So tenants, same as with the excess rent complaint, tenants do have to give a notice to the landlord about whatever conditions they're experiencing on the property and wait 30 days for a resolution before they can come to us. But when they do come to us, we want to make sure that whatever they're claiming on their petition was something that was noticed to the landlord properly, and we make them give us a copy of that notice as well as a proof of service form. But decreases can be awarded for the removal of amenities or housing services. So the laundry machine is no longer going to be available to the tenants. They can have their rent adjusted because they're not getting the same basket of goods for their rent dollar. Or if there's maintenance issues on the property, it could be interior or exterior, they can file with us. And then owners who want to remove a base amenity or housing service can file one of these decrease petitions as well. So if you're, for example, knowing that you're going to take away garages because you have plans to build ADUs, then you can come to us and we will typically mediate an agreement for the reduction in the rent because the tenant's no longer going to have the parking. And that's something that's, frankly, up to you. But if you do take away amenities, then just know that the rent can be adjusted as well. And there is no requirement of a 30-day notice for this. If it's an owner taking away amenities, just come to us and we'll try to take care of that efficiently. I mean, if you had agreed with the tenant for a certain amount, then bring us that agreement and our mediator can formalize that and reflect it in the maximum allowable rent for that unit. So what maintenance is required? Well, just about everything. So, rent control law does require that amenities be maintained and maintenance be done. And that's virtually anything on a property. And it even includes things that the tenants have damaged. So if a tenant broke a window, it's still the landlord's responsibility to fix the window. But you can then give the bill to the tenant, and if the tenant doesn't pay, just like anything else, you'd have to sue them in small claims court. But you need to be able to prove that it was the tenant who caused the problem. And we hear that about plumbing issues, so you have to talk to your plumbers about gathering whatever evidence might be needed. But it is the landlord's responsibility to maintain the property always. The other amenities, we consider, there's lots of things. Right now, for the post-1199 tenants, the only amenity that we really collect is parking. So on that tenancy registration form, the only thing we're asking about is parking. But there are many other things that are base amenities. It's whatever came with the unit. Did it come with a refrigerator? So the tenant negotiated the rent thinking they're getting a refrigerator. If you take the refrigerator away, then there can be an adjustment to the rent. I would point out too that for pre-99 tenants, so the long-term tenants, their amenities, as Stephen said, go back to April 10th of 1978. So the rent is based on that date, and so are their amenities. But there could be a difference between, say, a tenant who moved in 1994, and they had parking when they moved in. But their rent may not include parking. If it was the 1978 rent and it didn't have parking, that parking is not a base amenity for them, and they cannot file a claim with us because their rent isn't based on having that. That's something that they happen to get per the terms of their lease. So there can be changes, and also I know other landlords have asked, like between tenancies, if you go have one tenant, you get a new tenant, do you have to maintain the same amenities? And the answer is no. So you could have provided a garage to one tenant, and then now you want the garage for yourself, you've got a vacancy, you don't have to rent the unit with the garage. It resets with each new tenancy. We also look at all the things that are in the common areas, like recreation rooms or pools, gardening, everything. This is very similar to, can you hold your question till the questions slide?
Yes.
All right, I appreciate it. Again, we just kind of went over this for pre-99 tenants, it's 78, for post-99, it's what they had when they moved in. Another type of petition we have are construction-related rent decrease petitions. And so this is when a tenant is being impacted by either necessary construction or the voluntary upgrades or something like that. But there are some limitations. So we cannot grant any rent reduction to a tenant if there are unavoidable construction impacts when it's a necessary repair. And that's provided that the construction is being done in a reasonable manner and on a reasonable time frame. So, I'll give you an example of, let's say there's a balcony that has been deemed to be dangerous. So the landlord is required to repair that balcony. The tenant, might be able to claim, oh, that's interfering with my use of the unit, I work from home, and all kinds of problems. But we're not going to grant a rent decrease to them unless this repair is being done in some unreasonable way. Like we have seen properties where it takes more than a year for the landlord to start addressing that balcony problem. There is a range in the law of both the percentage of the rent for some things and dollar values for other things, how the tenant is impacted by construction. They're in regulation 4400, so when you ever see our regulations, 4400 means it's in chapter 4. So you can go to our website and look at chapter 4. And then it's slightly different from our regular decrease petition, because our regular decrease petition, we will calculate decreases from the time that the tenant files the petition with us. But with a construction-related decrease, the hearing officer does a finding about when did this problem begin, and the decreases are going to be calculated from that point, which may be in the past, but it's going to be applied to the rent prospectively. And mediation services available. So I think I have a slide here about how effective our mediation is. We don't want to have to bog things down with hearings, just as we know that the parties don't want to be bogged down in hearings, but sometimes that's the only way to adjudicate the issues. The other petition, this is one, two that landlords are interested in. One is the tenant not in occupancy petition. So just as a owner has to live in the unit as their principal place of residence to qualify for an owner-occupied exemption, rent-controlled units are supposed to be for tenants to live in as their primary permanent residences. And if you believe that a tenant is not living in their unit as their primary residence, there is a process that you can follow with us and possibly have the rent increased to either some kind of comparable market rate rent. If there have been comparable rentals on the same property within the last 2 years, then we'll use that amount. And you can also request a variance of that, saying, okay, well, this unit, is better because it's a little bit like, they're both 2 bedrooms, but one of them is larger, one of them has been renovated more recently, one of them has an ocean view, so you can request that amount be modified. If there hasn't been a comparable rental on the property, then we're going to look at the median of similarly sized units in whatever part of Santa Monica the unit is located in. And we publish that in our annual report every year. So there's a fixed amount that the hearing officer will consider. So, what are the things that we're looking at when we say tenant is not in occupancy? So, first of all, do they spend time in the unit? There isn't a requirement that it be 50% or more. It does have to be their primary residence and where they intend to return. So we would look at things like, are there personal possessions in the unit? Do they have any other property in the area? Are they married and their spouse has another property in the area? Where is their car registered? Where are they registered to vote? And the way this petition works is you just need to put together a prima facie case about why you think the tenant doesn't live there. You might have statements from an on-site property manager, personal observations, or the fact that your rent comes from Iowa. But once you make that prima facie case, you file the petition with us, and then the burden of proof switches to the tenant. And the tenant is the one who has to prove that they actually do live there. So if you want to pursue this, it's good to gather as much evidence as you can prior to filing, because that's all you really need to do, just to get the form filed. You do have to do things like notify the tenant at all their known addresses that you're intending to file this petition, and you have to wait 30 days, actually between 10 days and 30 days to file the petition. And we do have these come through the board several here. Then the other one is the individual rent increase petition. So This is the net operating income petition, or the one that I think many of you are interested in. And the rent control law provides that owners should always make a fair return. But the definition of that fair return is really a comparison of net operating income in 1978, prior to rent control, compared to a recent 12-month period. So we take the 78 amount, we adjust it for inflation, and then we compare it to a recent 12-month period. And if the net operating income is lower, then we can increase the rents on those units such that the owner is now making a fair return. The challenge that most property owners run into, though, is since Costa-Hawkins has come along and now 75% of the units have been rented at market rate, on most properties, the gross income is so much higher that even with expenses, an owner is still making a fair return according to the formula that's in the law. This could change, you know, we've had people who, you know, have to do re-roofing and replumbing, and they have to do an earthquake retrofit, and, you know, they need to comply with the electrification that's coming down the road. So with those large capital expenses, it's possible that the owner would qualify for a rent increase with this petition. We have staff who can talk with you about your costs and kind of run through the numbers with you to see if there's a chance it would be worth filing the petition. But to be honest, we have not gotten very many filed because in most cases, the simple calculation just shows that the owner is continuing to make a fair return based on the higher market rates. I did mention the effectiveness of mediation, just some numbers here. So we get 95 petitions for decrease. So a couple a week, you know, once a month for the excess rent, and 2 a month for construction-related decreases. But we're pretty effective in resolving a lot of the issues through mediation. We have a contract mediator, and that streamlines the adjudication. So, do we have any questions about this? All right, hands are going up.
Is anybody able to get a rate increase based on
Not that I'm aware of, no.
very expensive?
Yeah.
What was the question?
And the question was, has anybody qualified for a rent increase based on one of these individual rent petitions based on earthquake retrofitting? And the answer is no, not that well. I think some people have come to us, and I think there might be one that is in process. And I think that person did have earthquake retrofitting along with some other major costs.
Here.
Hi, I have a question. Sorry. So I have a question regarding the rent increase. So if you have a tenant that you find out they're subletting, like on Airbnb, and in our lease agreement, we have like a 5% increase on rent if we find out you're subletting. So when we're determining the MAR, is that able to apply that increase that we applied on the tenant?
Nope.
Or we still have to go back to the original rent that they're paying?
Yeah, that would be an excess rent charge. You can't increase the rent 5%.
Even though it stayed in the lease agreement?
Even though it stayed in the lease agreement. Your remedy there would be to give a warning notice to the tenant to comply with the rental agreement and stop subletting.
Is that a cost for eviction?
If it's a violation of the rental agreement, then yes, it would be, because one of the reasons for eviction is violating the rental agreement. It has to be a substantive one, and it's going to ultimately be up to a judge whether or not the tenant should be removed. But that's the remedy that you have, is to give a warning, tell the tenant to comply, and if they don't comply, seek an eviction. Owners are required to file copies of eviction notices with us, and I have seen that as a reason. Whether or not the tenant was actually evicted, I don't know, because that all happens in the courts, and we don't have the resources to track what's going on in the courts.
Thank you for your presentation. Can you give us a number at some point, what fair market value is? You throw that number, you throw it out there, fair return. What is the fair return? What's the number that you're using? It's an arbitrary number that has no teeth to it.
Well, the fair return is what it's based on, what was the 1978 net operating income. So it's different for each property.
I didn't own the building in 1978,
Right.
so I couldn't tell you.
Right.
1978 is a long time for people to hold on to paper trails, and I don't think that you could prove it in 1978 either way, and I think it would become a matter of a dispute. So why don't you just come up with an actual number that you can give us every time you make a presentation? It's a request that you bring back to your people.
Okay, there's a part of that I wanted to respond to. I'm sorry, no, I wanted to let you know, when owners registered their units in 1979, when rent control started, we asked for that financial information. So in most cases, if the owner complied, we have those records at rent
Owner
control.
occupancy, didn't comply, no income.
Okay. There is a provision in this petition where you can look at a most recent year where you have information.
Is it possible for your department to eventually give us a number of what you feel is a fair market return, please?
It's based on each property, so I can't.
The fair market return is 10%, 20%, 3%, what is it? It's not based on each property, I think you're just not willing to give us a number.
Well, I have to go by what is the formula in the rent control law, and that's all I can tell you. And it is based on each property. So.
What is the formula? What is the formula?
So we look at the net operating income of 1978, and then we adjust it for inflation, and then we compare that to a recent 12-month period and see which number is higher. It's a very simplified explanation.
Thank you for your attempt anyway, Dan. I noticed on your slide and thank you for the presentation. On your slide presentation, you indicated two areas where the base amenity involved the right of a tenant to demand a roommate and the right of a tenant to insist and demand that they have a household pet. Do you recall that on your slide?
Okay, yeah, so I don't know if I, let's see. Do you mean here?
There it is, thank you.
Right, okay.
Right
So-
to have a roommate and right to have a pet.
Right.
Thank you.
Okay, so the base amenity, again, we're gonna go back to whether the tenancy began before 1999 or after. If it was before 1999, we go back to April 10th of 78 and may or may not have information about how many people were allowed in the unit for that amount of money, for the amount of rent that was charged. If it was determined, let's say that a family of four people lived in that unit, or let me simplify, let's say two people lived in that unit, and you have a tenant who moved in 1996, and they moved in as a single person. Their rent is based on the 1978 rent that allowed two people to live in the unit. So they can request that another person move in because that is the base, that's the amount, that rent was set with the idea of two people living there.
No.
Well, why is it fair to charge the same amount of rent but allow fewer people? Well, but, that's why we're here explaining the rent control law. There's a big difference between 1999, earlier, and 1999 after. So let me give you.
Marty, he explained it.
Let me give you the after 1999. So,
He explained it, but let's just walk through it. In 1978, is that when the rent estate? 78. The owners were obligated, were they not, to file a little card, and they would just check off cooking facilities. I don't recall on that card whether they had to identify the unit as a studio, as a 2-bedroom, as a 1-bedroom. Can you refresh my memory? Does the card require that?
Mike, it was an 8x14 sheet of paper. It wasn't a card.
Okay.
yes, Mr. Nate is right. So it was a big sheet of paper, and it did require that they identify the number of bedrooms in the units, the square footage, approximate square footage, and certain amenities that were pre-listed.
Well, that was in 79. The original was a card. We know that to be true. Before the sheet of paper.
No, we
Because I saw one of those cards when I bought my property. So here's direct evidence. I saw the card when I bought my property.
okay.
But I'm asking you, did the paper indicate the number of rooms and the number of occupants?
So it did identify the number of rooms, but it did not identify the number of occupants. And here's the thing. So if a tenant were to file a petition and claim that they're not being afforded the same number of roommates as there were in 1978, the burden of proof is on the tenant. They have to provide the evidence to the hearing officer that 2 people lived there in 1978. If they don't have that evidence, the hearing officer cannot reduce the rent for that. If it were something like refrigerator, and it's clearly checked and says refrigerator, 1978, and now there's no working refrigerator, that's easy.
And that's the same analysis for the right to have a pet.
Yes, if they're
That
pre-99,
card or that sheet of paper,
yes, did not
check
have
the
anything about
box
pets.
that said pet, correct?
It did not have anything about pets.
Nothing
So
about pets.
if a tenant wants to claim that in 1978, the tenant had a rabbit, then they are gonna have to come up with the evidence. Now, for post-99 tenants, you set a new base rent, and however many people moved in on the base rent date is the base amenity. So, from January 1st, 1999 and forward. So, if a tenant, let's say 2 tenants moved in 2019, and one of them now is moving to San Francisco, the remaining tenant has the right to replace that roommate. So they have to give you a written identification of who that person is, and if you refuse, then the tenant could file a petition for rent decrease because they don't have the same amenities or housing services that they had when they moved in. The rent's the same, but now that only one person's allowed there. Separately, let me just finish one more part of that. So,
You're saying that a roommate's an amenity now?
yes, it's a
That doesn't seem right either.
well, I mean, tenants, when they move in, they think, all right, well, there are 2 of us, and 2 of us can live here. And if you say, well, now only one of you can live here, obviously their rent's gonna double. So, well, if they pay the same rent, how is it not doubling? Anyway,
Because you're renting the space.
yeah, that person would have to pay the full rent in order to not be evicted. So that's why they should be able to replace the roommate. Now, if a rental agreement says that there is no subletting, so this gets into reasons for eviction. This is separate from amenities. So normally, if a tenant is violating their rental agreement, that could be a reason for eviction. You're subletting, and I told you not to do that. But there's an exception that says if you are replacing a roommate on the lease on a one-for-one basis, and you continue to live in the unit, and you have given the name of that person to the landlord, and they have not unreasonably refused, then you can't be evicted for that.
First of all, thank you for your terrific effort to try to explain some very, very complex, complicated issues such as roommates-based amenities and the ability to track it back to 78. So I tip my hat for your effort to try to do that situation. My only comment is, long before you apply to a hearing officer for a determination which is quite expensive, I believe the rent board or the rent staff should be able to intervene and explain to the tenant, I am sorry, there is no evidence that you can bring forward that you've shown us that would support your petition, and you're just taking up our time, and it's really not appropriate.
Right. We don't, I mean, to be honest, we don't have that many petitions for, pre-99 tenants replacing roommates. But we do explain to the tenants when they're filing petitions that the burden of proof is on them. So I think we got a couple more questions, and then.
Thank you.
Do you have a printout of the slide?
We don't have printout, but we will put it up on our website. So if you go to the seminar, newsletters and seminars page of our website, you'll find it there.
Can I ask a question that follow up the roommate situation? So do we need to register, submit the names that we're given of roommate? So in that case, like if John moves out, Peter moves in, right? John's name is still going to be on the lease. Then like if, Mary and Peter moves out, and then John can come back and say, I'm still under rent control instead of a new tenancy?
Well, that's a lease question, about, what we're looking at is, and we don't collect any tenant names. All we're saying is, when did this unit get rented and for how much? That's the information basically that we collect and maybe department. And if there are changes, then it may be you can talk with us about the particular situation, and maybe we could say, it looks like, this is a case where you would be able to set a cost to Hawkins rent, set a new rent because that tenant moved out, you have, new tenants, and then this person moves in. I don't think that happens a lot.
Well, the other one, I just want to make maybe a feedback. I try to look into increase, apply for rent increase, net operating cost, and it's so complicated. And the fact that I remember a few years ago when I went to rent control outlet, before you even moved to the main building, that the staff can print out like a really big, back in the day, big sheets of the base amenities and even the rents at the time. That, like you said, the registered owners registered in 1978. Is that information available in the civic system? Because it's in your system.
Right. No, that information is available upon request. The Civics doesn't have it. We do have an online document portal, and it has all of our scanned documents, but it only goes back to 2005.
Okay.
And for those earlier documents, you can just email us and say, can you send me the original registration form for such and such property? And we'll
Okay, we can also ask for, I can send email, ask for that base rent, and even when you talk about calculating inflation, there's got to be a published inflation percentage that you can it be published?
Yes, I think, I know that we have those figures. Yes.
Thank you.
Isn't it possible that if you have multiple tenants, if you have multiple tenants and one comes out, you should allow them to add a different tenant, but not put them on the lease?
Yes, it's not required that you add them to the lease. Because you already have your original tenant on the hook for the rent. And you may want to talk to an attorney about whether or not you want to have somebody in the So, okay, so
Hi, I had a question on the two roommate situation you were mentioning earlier. If one does stay behind and the other roommate's like, I found someone to replace the roommate that moved out, do they have the control or do we have the control to say, oh, we don't agree with that tenant and the qualifications? Because if they just shoot someone off the street, they can pay the other half of the rent, and that would be like an issue. Or is it just like the normal screening process where we kind of do the application process and everything?
So it's not entirely clear. So if, if you just refuse, it's going to be a question of are you reasonably refusing or not? And if the tenant were to file a decrease petition with us, the hearing officer would make that decision. Ultimately, you don't have to put that new person on the lease. So it's really your original tenant is the one who's on the hook for the rent. And then if it's a situation where it's a sublet, the lease prohibits subletting, but they're now replacing person, you cannot unreasonably refuse. What is unreasonably refusing? That's going to be up to a judge. I can't tell you.
This is a two-part question. The first part is when a rent decrease is granted and the situation is thereafter cured, the landlord can then request a reinstatement of the old rent, and it goes back up to what it was before the decrease once it has been cured. Is that correct?
Yeah, thanks for
Okay.
because
Because I think, from what I've heard, a lot of landlords get the decrease petition, don't realize once they fix the situation that they therefore can request their rent to go back up to what it was before the decrease. Number two is on the, in the history of the Rent Control Board, the amortization, we're talking about fair return. The fair return is based on all current expenses, and those current expenses are allocated now over a 40-year amortization, is spread over a 40-year period. Originally, it was a 20-year period. Is there any consideration in the rent board to reduce the amortization periods down to a logical timeline?
Right. So no, that not each item sort of has its own amortization period. So a roof might be 20 years. Plumbing, I know that there are some that are down to 5. But you'd have to go to Regulation 4400 and list them all, and it shows what the amortization rate is for each one of those types of capital improvements or repairs. Okay, I think, how about that woman in the teal back there, and then, I'm sorry.
It's two questions. So do we have, originally it's just one tenant that signed the lease, but he has a friend, a girlfriend, a boyfriend moved in. Do we have the right to vet that second person? Fill out an application and all that?
Again, you can't unreasonably refuse. So, I would imagine that a reasonable vetting would be fine.
Yeah, make sure they're not a felon,
Right, but if it, if you still, refuse them despite, what a normal person would consider to be fine, then that could end up with a rent decrease.
The second question is, we have a pool, and it has a heater, but nobody ever uses it. But we have a tenant that insists that we heat it all the time. Are we responsible to keep it heated?
Well, you don't have to heat it, but the tenant who had a heated pool as an amenity could file a petition with us. I know that the hearing officers take evidence about how often do you use the pool, and if they can't establish that they use the pool much, then there's hardly any reason to decrease the rent because they don't use it. They can't just, but it's up to you whether or not you want to heat it. Okay, yes.
Yeah, thanks. Just to further the situation, if two people signed a lease and one leaves, the other one brings in another person, according to the fairness of, paying the same rent. And then that person, the original person for lease leaves. So there's another person in there that isn't technically on the lease, but you've approved them being there. Can you opt to put it on the market with that person in there? Or do you have to continue with that person?
Well, So one of the reasons for eviction is that the unit is, that the original tenant has left and the person remaining in the unit is a subtenant not approved by the landlord. In this case, it may be that they're approved, but could you set a market rate rent with them? That's case by case, but if it's, I mean, there is certainly the possibility that you didn't put that new person on the lease, you don't treat them as a tenant, you don't accept rent from them. So once your named tenant is gone, under Costa Hawkins, you should be able to set a new market rate rent with that person, and they can decide whether or not they want to stay there or not. All right, yeah, we got, I think we're just gonna, since we're over time already, I think I've talked about the limitations on evictions, but I do want to know you do have to send copies of eviction notices to us if it's anything other than non-payment of rent. And you also have to send to the city attorney's office. So we require within 3 days, they require within 2, and if an unlawful detainer is filed, they also require that you provide more information to them. Warning notices are required if it's a lease violation, they're denying you entry, or they're creating a nuisance on the property. You have to give them just a warning first, with some reasonable time for them to comply. If they don't comply, you can go forward with the eviction notice and send a copy to us.
If it's a non-payment of rent, don't get involved.
No. Yes, so any eviction notice that you serve on a tenant, other than non-payment of rent, you have to send a copy to rent control. And you send a copy to the city attorney's office as well. I think we talked about that. Do you want me to go into evictions for owner occupancy?
Sure.
Okay, so.
No.
I'll go quickly then. So if you own at least a 50% interest in the property, you can evict from one unit only to move on to the property. There are limitations about which unit you can select. If there's a mix of units on the property, with like 1, 2, 3 bedrooms, you can select the one you want. If there are 2 or more of the same type, comparable units on the property, you can only evict the tenant who moved in most recently into that type. And you are supposed to agree to live there for 2 years. And if you evict for owner occupancy, the Costa Hawkins doesn't allow you to reset the rent for the new tenant when you move out. It's going to be the rent for the old tenant, plus any general adjustments that have occurred. Yes, under those conditions that we just discussed. If you're evicting for owner occupancy, you do have to pay permanent relocation under the city's permanent relocation. It varies depending on the size of the unit. It depends on, and how long if the tenant is senior or disabled. But there's a schedule that's published on the city's website for relocation. There are also eviction protections for students and educators during the school year. You can't evict the spouse, or tenant if they have their spouse move in, or their domestic partner, or their dependent child. So just skip over those. And lastly, we'll just talk about, as I said, one of the pillars of rent control is preserving the housing stock. So you can't just take a controlled rental unit and turn it into something else. You have to get a removal permit from the board. And that usually requires that you're going to build a replacement unit. There is another kind of removal permit if a unit is uninhabitable and cannot be made habitable, like never conform. That can be subject to removal. The Ellis Act, which we haven't gone into, but you're probably all very familiar with, but that's going out of the rental housing business, and you're no longer under rent control. You have to find some other use of the property. But if you start renting again, it depends on how soon after you've withdrawn whether or not the property will be subject to rent control. If you revert to the old rent, or if you can set a new base rent. And then if you redevelop the property and offer it for rent within 5 years, it's gonna be subject to rent control anyway. If you wait beyond the 5 years, then it wouldn't be. And then, as we just mentioned, permanent relocation benefits must be paid for all no-fault evictions, including Ellis, removals, evictions from occupancy. And I'll just skip over that since I already summarized it. Last thing is just about buyout agreements. I think you may know that you are required to file a copy of the buyout agreement if you do negotiate with a tenant. And it's voluntary on the part of the tenant to enter into it. They can consult with an attorney or us. We publish the average amounts for buyouts on our website, and tenants can look at this. The minimum buyout amount has to be what permanent relocation would require, and so you have to check that. And then just as a new city ordinance, it is considered harassment if you continue to offer a buyout offer to a tenant after they have refused in writing, saying they're not interested. If you continue to pester them with buyout offers, they can file a harassment complaint with the city attorney's office. And that brings us to the end. So as I said, we will post this on our seminars and newsletters page. We'll post the presentation itself. And then if you want to comment to the board on whether or not they're going to impose a dollar cap ceiling or comment on the budget, their next meeting is June 12th at City Hall at 7 p.m. as always. Well, thank you very much. I really, really do appreciate everybody coming out and trying to learn a little bit more and frankly avoid problems. We're here, about half of the 11,000 calls we get every year are from landlords. And so, we're here to help you just at least understand the law. Maybe it's not the law you'd like to have, but we'll tell you what it says. Okay? Thanks so much.